Welcome everyone for a really exciting session that I'm having with Neda, who's written a fantastic article for Data Privacy Week on something that I think is often overlooked, and that is lawful justification for processing personal information. Neda, I know that a lot has been said about consent. I know your topic addresses whether consent is a good lawful justification or not. Maybe you can tell us, what are the other lawful justifications in addition to consent?
Thanks, Beulah. That's exactly why the article was written, to discuss whether consent is indeed the fairest of them all. There are several lawful justifications that a data subject can rely upon. It doesn't necessarily need to be consent on its own. It could be you processing personal information to conclude or perform in terms of a contract. It could be to fulfill a legal obligation. It could be that it is in the legitimate interests of a data subject. It could be to fulfill a public duty as a public body. And lastly, it could be in the legitimate interests of the responsible party.
Okay, so 5 additional justifications. Absolutely. In addition to consent.
Yes.
And what do you make of this thing that I'm seeing a lot of when I'm reviewing contracts and terms and conditions, where the organization is asking for blanket consent? The data subject, you are consenting to any and all processing of personal information by the company, and you sign the dotted line and the company is good to go. Is that the case?
So responsible parties are often cautioned about embedding consent into the terms and conditions. It was never intended for consent to be a primary justification in order to process personal information. And what responsible parties need to look at is, in fact, what is the most appropriate lawful basis in order to process the personal information.
One of the things I think is really useful for organizations to think about, a good litmus test in determining if consent is the correct justification or not, is this question that I ask them, is what would happen if you were to withdraw consent? Would you be able to give effect to that consent withdrawal when the data subject exercises it or not? Do you think that's a good litmus test, Neda?
I think it's a fantastic litmus test, and let's look at it by way of a practical example. If you have a service provider that has relied on consent as the ground of lawful justification in order to render services in terms of a contract, the question then, exactly like you've said, what happens if that consent is withdrawn, or even if from the outset the consent is withheld? Must services be terminated? Does that mean you lose your client base? Does that mean you can no longer render services anymore? Or is it that the most appropriate lawful justification was contractual necessity, not necessarily consent?
Right.
So you're processing data subjects' personal information on the basis of contractual necessity.
Okay, that makes sense. So maybe I can ask you a different question. So we have one set of personal information, but we're using it for different purposes. That often happens in an organization. Is it then that you have to rely on the same legal justification, or can you have different legal justifications for that personal information?
Yes, so that's exactly right. So for every personal information set that is being processed, you can have more than one lawful justification, provided that it is for different purposes. So the ultimate rule is that for every purpose, there must be a ground of legal justification.
All right. So for example, if you got an example where that might be practically used.
Absolutely. So let's go back to the example I gave previously. So if you are entering into a contract with someone, you're using their personal information to enter into the contract and perform in terms of the contract. You're going to be using that personal information set on the grounds of contractual necessity.
Okay.
But let's say, for example, you want to use that information to now starting to market or to directly market to that data subject to provide additional services. The same personal information set, you're now going to rely on consent, where you've obtained their consent for the direct marketing.
Okay, so possible, and it's all within the requirements of POPIA.
Very compliant to do that, provided, like I said, that every purpose has a legal justification.
Okay. And then what do you make of this where clients, and I'm seeing this more and more, they say they are relying on consent, but also in addition to consent, they're going to be relying on a different lawful justification in case consent is withdrawn. What do you make of this backup justification stance that companies are taking?
So clients are cautioned not to have a backup legal justification. The regulator in the UK themselves have come out with a guidance that has said that you should determine the legal justification from the outset, so before you process the personal information, which means you can't swap the legal justifications during the processing of that personal information for that purpose. What we've also seen is that regulators, in determining whether companies are compliant with the GDPR, for example, have not taken too kindly to relying on two lawful justifications. For example, Meta has recently been fined just under 400 million euros
Wow.
for relying on both contractual necessity as well as consent.
Sure. Okay. So that's a big no-no.
Yes.
Okay.
Don't have a backup lawful justification.
All right. Got that. Then maybe my last question, and I think after this really interesting article, there's going to be many people with these questions for their data privacy officers. What are some practical tips that we can give to organizations, to data privacy officers around establishing a lawful justification and making sure it's compliant with POPIA?
So if we take it a step back, when POPIA was enacted, a lot of people rushed to become compliant with POPIA. What we do suggest is that your lawful justifications be analysed again. So basically start from the beginning to ensure that where you have relied on consent, is consent indeed the most appropriate lawful justification of them all.
Okay.
The next thing what we would recommend is that your lawful justifications per purpose is recorded. This, what we've seen at clients, is usually in a record of processing activities. We suggest that this be visited regularly, it be updated, it be maintained to make sure that you are aware of what lawful justifications are being relied upon.
All right.
The next tip we would give is that you remain transparent with your data subjects, which means that you need to disclose to your data subjects, or at least notify your data subjects, which lawful justification you will be relying upon. Okay. You cannot mislead them in saying that, we're relying on consent, but in the event that consent is withdrawn, we'll continue processing your personal information.
Absolutely.
Like I said, you've got your giant companies. You've got Meta, which is Facebook and Instagram. You've got WhatsApp. You've got numerous companies that are currently being fined for this sort of action, ultimately not being transparent in terms of what lawful justification has been relied upon.
I think those are great tips, and I think it's something every company can put in place immediately. So thank you, Neda.
Thank you, Beulah.
I look forward to seeing your next article, whatever the topic is, and we hopefully have another one of these sessions.
Brilliant. Thank you very much.